Everybody, good day. My name is Steve Blake. I'm here with Andrew Hall to present a webinar today on 2025 notable changes in California real estate law. Myself, Steve Blake, I'm an attorney and one of the shareholders at the Blake Law Firm. I've been practicing real estate law for 20 years, and a lot of our clients here at the firm are commercial and residential property owners, landlords, tenants, buyers and sellers of commercial and residential real estate. And so we wanted to give this presentation today so we can inform our clients and other people interested in some of the new laws affecting property owners in California. And Andrew, do you want to introduce yourself?
My name's Andrew Hall. I'm a senior counsel and shareholder at the Blake Law Firm. I have over 16 years of experience in the real estate legal industry, and we're excited to share some of these new laws taking effect throughout the past few months and into next year as well. So we look forward to any questions you might have when this presentation's over. Feel free to contact us.
And there's a lot of laws that have changed this year, and some of them are, new laws that are new to the books. Some of them are laws that are amending existing laws, and we're going to go over the ones here on this slide in our presentation today. And our intent is to not give legal advice, but just to give a high overview of what these laws are and possible ways that they will affect commercial and residential property owners. AB 98, this is a new law that involves commercial properties, and it's targeted at commercial warehouses and logistics facilities. And the intent of this law is to regulate the construction of new warehouses and logistic facilities, and also to regulate the expansion of existing buildings. So it changes the way that warehouses are developed and operated, specifically logistics facilities. So think of, buildings where there's like an Amazon facility where there's big, heavy trucks coming in and out of the building and the property on a day-to-day basis. And the state of California is trying to figure out ways to integrate those types of facilities in, more densely populated areas where it could cause a lot of issues with traffic congestion, noise, potentially pollution. So this bill regulates different ways in which commercial property owners of those facilities need to develop their property. And, some of those things are like figuring out what the traffic plan is going to look like for the heavy trucks coming and going from the building, how it's not going to create an excessive burden on the existing surrounding area. So this is something that commercial property owners are going to have to pay attention to going forward. And, there could be quite a bit of red tape that they're going to have to go through in meeting this criteria.
AB 2904 amends section 65854 of the California Civil Code. It applies to zoning, specifically where there's a zoning ordinance or amendment to a zoning ordinance that affects permitted uses of real property. This applies to both residential and commercial properties. And what it says is if the ordinance affecting a permitted use of real property, then the notice period extended required by the city or county making the change must give notice within 20 days. This is a change from the current law that was notice of 10 days. If the proposed ordinance doesn't affect permitted use of real property, then the 10-day notice still applies. So, for example, a 20-day notice would not apply for something like a conditional use permit. Those are approved by resolution, not by ordinance. So for a CUP, a 10-day notice would still be applicable. The 20-day notice would give impacted property owners more time to prepare and make arrangements to attend any hearing on any zoning change. So it is beneficial to both commercial and residential property owners that may face a change in a permitted use of a zoning affecting their property.
SB 1103 is a new law that has taken effect that amends a few different sections of the Civil Code. As you can see, 827, 1632, and 1946.1. And what this does is affects commercial property leases, specifically leases that are for a month or less, so less than 30 days. And it applies to qualified commercial tenants in commercial property leases. And it limits the amount of rent that a landlord can increase the rent by. As you can see here, if you're gonna increase the rent by greater than 10%, you're gonna have to give 90-day notice before the effective date of the rent increase. Whereas if it's less than 10%, you can give a 30-day notice. And qualified commercial tenants is not obviously every tenant. The civil code defines that as a micro enterprise, which is a restaurant with fewer than 10 employees or a nonprofit organization with fewer than 20 employees. So the law doesn't apply to all tenants, so be careful when reviewing that to make sure it applies to your tenant or not if you're planning on increasing the rent on a tenant that's less than month to month. And then 1632, this is pretty straightforward. It just amends the statutes to require the landlord to provide the lease in the language in which they are negotiated. So that's pretty straightforward. Section 1946.1, this applies to leases with less than 30 days or an unspecified term. So if you have that case and you want to terminate that term, you need to give written notice, and this amendment tells you how much written notice you have to give.
AB 2579 amends section 17973 of the Health and Safety Code. It's the balcony inspection statute. It applies to residential properties that consist of buildings with 3 or more units that have balconies, stairways, or elevated structures. Elevated structures are defined as structures that are at least 6 feet off the ground. Under the prior law, an owner of a property covered by the statute must have completed an inspection of the balcony no later than January 1st, 2025, and then subsequently conducted inspections every 6 years. This bill amends the Health and Safety Code to extend the deadline from January of this year to January 1st of 2026. If you have a building that falls within the ambit of the law, you'll want to make sure that you conduct that inspection by January 1st of next year to ensure that you're in compliance. And somewhat of a companion is another balcony or exterior elevated inspection statute. It's AB 2114, and it applies to homeowners associations, condominium associations, etc. And it amends California Civil Code section 5551 under the Davis-Sterling Act. It requires that it actually took effect in July of 2024, but it requires that HOAs containing 3 or more multifamily housing units are to perform an inspection on wooden or elevated structures. Elevated structures, again, any structure that's 6 feet off the ground. And those inspections are required to take place every 9 years. Under the original language, the inspection not only had to take place by January 1st of this year, which remains in place, but the statute or the bill extends the persons who can conduct the inspections. Originally, only a licensed engineer or architect could conduct the inspection. Now civil engineers can conduct it. It's intended to extend the pool of potential persons that could inspect the balcony and ensure HOA compliance with the code.
SB 900 is relevant to HOAs, and it amends section 4775, 5550, and 5610 of the Civil Code. And historically and under existing law, an HOA is responsible for maintaining and repairing common areas of the property. And what this law does is it expands the HOA's responsibility for maintenance and repairs. Obviously it still includes the common areas, but it also includes other areas that are damaged, even if they extend into a member's unit as opposed to a common area. It also changes the ability of an HOA to assess its members, and it's focused on emergency situations. So for example, if there's a a water pipe that bursts at the property and it causes a lot of damage, the HOA can now, under the statute, declare an emergency assessment, and there's different rules that would apply to do that. But the law gives HOAs a little bit more flexibility to assess the members for maintenance and repair of the buildings, but it also creates more liability for the HOA to maintain and repair the building, especially in sections where historically they may not have taken responsibility, such as inside a member's unit.
This bill amends section 1950.6 of the California Civil Code and applies to tenant application and screening in the residential lease complex for residential leases. It does not apply to commercial leases. It applies to properties containing 1 to 4 single-family dwelling units. And what it says is, in order to charge an application fee, a landlord must do a few things. They must process applications in the order received. They must delay charging fees until the application is actually reviewed. And they must approve the first applicant that meets the screening criteria. In addition, it also implements a refund mechanism whereby if an applicant is not selected within 7 days or no decision is made within 30 days, the application fee must be refunded. So notably keep in mind that this applies only where a landlord or property manager charges an application fee. If there's no application fee charged, then the new statute doesn't apply. And then AB 2801, kind of another landlord-tenant related change. It amends section 1950.5 of the California Civil Code. This takes effect in July of 2025, so there's a few more months until this law sunrises, but it applies to residential leases only again. And it's a significant change to how security deposits are handled. What it does is it requires landlords to provide photo documentation when making deductions from a tenant's security deposit. So the requirement that a landlord provide an itemized statement of deductions is still there, but in addition, a landlord must provide photographic evidence of the condition that is being deducted. It also requires that the security deductions include evidence of the condition of the property before occupancy. This begins again in July 1st, 2025. So any landlord before the tenant takes occupancy or at the time of will want to make sure that it takes photos of the condition of the property. And then when that tenant moves out, photos will need to be taken again to memorialize the condition of the property and any deductions that the landlord intends to take from the security deposit. It also prohibits automatic changes for professional cleaning and carpet cleaning unless they're reasonably necessary to restore the property to the condition at the beginning of the tenancy. So rather significant change to how security deposits are handled.
And AB 2747, this amends or adds Civil Code section 1945.07, and it's positive rent reporting, which is new to the state of California, but it only applies to buildings, residential properties with 16 or more units. And in those types of properties, tenants have the option of asking the landlord to report a positive rental payment information to one of the credit bureaus. So in the past, landlords would often report negative credit to the credit bureaus, but here the landlord can report the positive. And there's some intricacies to the law where starting this year, the landlord is required to offer this option to the tenants. And so that has to be in writing. And then the tenants, if they are interested, they would have to respond to the tenants or to the landlord in writing. So there's some requirements as to how the positive reporting gets handled, but it's just a new twist in the law that landlords are going to have to pay attention to and provide their tenants with notice of that option to do this. And SB 611, this is a law that's aimed at trying to create transparency between landlords and tenants. And the purpose of the law is to prevent landlords from charging tenants with hidden fees. So they need to clearly state in the property agreement, any type of costs that are in addition to anything, such as one-time charges. If the landlord, let's say that you pay rent by check and your rent is $1,000 and the landlord charges, a $3 fee for that check, that $3 fee needs to be disclosed in writing to the tenant. So this is important for landlords to know and comply with. There are penalties if they do not comply with this. So any residential landlord needs to be aware of this new law.
AB 2347 is, from a litigator standpoint, it's a rather substantial change, which I'm sure Steve could attest to. It's changed a law that's been in effect since 1970, so it applies to both residential and commercial tenancies. And under the new law, a tenant had 5 days to respond to an unlawful detainer complaint once they were served. So rather quick turnaround. And now tenants have 10 days to respond, doubling that time. So the potential impact is that it will certainly slow and potentially significantly the unlawful detainer process. And from a landlord property manager standpoint, you could see non-paying or non-conforming tenants able to stay in the property longer as a result of this change. Landlords will want to make sure that their records are that much more in order, ledgers accurate, leases in order, amendments in order. Because the time cost in having to restart an unlawful detainer now is that much higher, especially if a notice is defective or the records are inaccurate. Having to start over could have a significant impact on the landlord or the property manager.
One Proposition 33 that we wanted to just address was the rent control, which failed. It did not pass. And the state of California voters, they rejected a proposition that would have created additional rent caps across the different counties and cities. So we wanted to just mention that. And then this other one, AB 2216, it hasn't been signed into law yet, but it's lingering around the legislature. And it's essentially trying to limit what a landlord can charge a tenant for pet deposits or pet rent. And historically, landlords have charged different things for that for tenants. And so they're trying to make that consistent throughout the state. And then it also is intending to ensure that landlords with more than 15 rental units in a building cannot deny a tenant the right to have a pet. So we'll keep an eye on that one, but that could come into effect in the next year or so. So that's it. That's what we wanted to update you guys on. Thank you very much for watching. Andrew, did you have anything to say in conclusion?
No. If you have any questions, feel free to reach out. Obviously, this is a very summary of the law, and there's some, as Steve mentioned earlier, some intricacies involved with each. So if you have any doubts, be sure to consult an attorney about your rights and remedies.
Thank you very much, and we hope you enjoyed the presentation. Have a great day.
Thank you.